Welcome to World and Copyrights Day, organized by our IRRO, Indian Reprographic Rights Organization, and FIP, Federation of Indian Publication. So, moving on, today we have a very interesting panel with us. Our really amazing chair, Mr. Rishabh Sinha, General Counsel, Flowbiz. It's a great honor to have you here, sir. Thank you so much for being a part of our event today. Moving on to speaker one, Mr. James Mimico, Board of Director, Greek India Business Associate, author, and film producer. Thank you, sir, for being a part here. Moving on to speaker number two, Mr. Utpal Chakrabarti, Chief Digital Officer, Allied Digital Services, former head of artificial intelligence at Yes Bank. Thank you so much, sir, for being a part. Such an honor for all of us here today. Moving on, Mr. Shrey Gupta, Associate, Ajay Sinha Association, LLP. Moving on to the last and our final speaker, Mr. Ankit Sinha, Partner, Ajay Sinha Associates, LLP. Thank you so much for everyone for joining us. Moving on, so I would like to move on to Mr. Rishabh Sinha to conclude the session, to start off with the session.
Thanks, and thanks, Team Pragati. Thank you for the introductions. Today we are gathered here for a topic which is raising a lot of eyebrows, causing a lot of debates globally. We are here to talk about
Sorry, sir, I'm cutting you in. We just left with one introduction. Sorry, the mic got glitched, so I had to turn off the camera. So I just left with Mrs. Shruti today. So, yes. Sorry. This was just a glitch from the camera. So, the final guest and the very important one, Mr. Shruti Chaudhary, LLM candidate 2022, co-founder of BLIT, member of Open Source Committee, Boston University, California. It's a great honor to have you here, ma'am. Thank you so much for being a part.
Thank you, Team Pragati. I believe that rounds up our introductions. Suriti, my apologies. I didn't realize yours was left.
That's all right.
So, coming back to what we were speaking about, we are gathered here to discuss what implications creations by artificial intelligence may have on IP law, specifically copyright law. We have an interesting panel was graciously introduced by the Pragati team. I'll just go over once again. We have James Mimikos, who's joining us from Athens, Greece. He's a creator and an artist. He's a lawyer turned creator and an artist who is currently a movie producer and writer. Utpalji was formerly leading AI initiatives at Yes Bank and is currently with Allied Digital. Suriti is at UC Berkeley. She is researching on the implications of AI on IP laws. And last but not the least, we have Shrey Gupta. He's a lawyer with the top IP law firm in India, Ajay Sahni and Associates. Now, today, in the field of artificial intelligence, there's, it's one of the most complex and astounding things that computer science is doing today. There is a lot of development, many projects going around, and a lot of debate on what AI can achieve today. We have remarkable real life and real world projects, everything from self-driving cars to disease mapping, emotion recognition, even projects in early stages of developing a fully self-aware AI. And this leads to a lot of conspiracy theories and various kinds of speculation on what this will mean for the human race. Will this mean that we will be out of work? Will this mean that we will be slaves to a fully aware and conscientious self-aware AI? And the field sometimes tends to be divided between those who look at scientific progression with hope and curiosity and those who may see that this only portends doom and gloom. Is AI going to take over? But as juicy as these questions may be, we are not here to discuss that today. What we want to discuss today is artificial intelligence not in the shoes of a conqueror, but in the shoes of a creator. What can AI do for progressing arts and culture? So today we see the same thing that programs which are helping write out entire news stories, programs which belt out artwork, after being fed on a training diet of Rembrandts, projects which write up entire literary novels which make it to advanced stages of literary fests as being great works of art, music compositions, poetry, the list just goes on. All of this, it begs the question, what is the legal status of these creations? And not just the legal status, what do these creations mean for us? Is it something, if an artist uses some of these AI creations as a part of their own project, are they still at the same level as an artist who did it completely on their own means? Or more significantly, who owns some of these innovations? So is this innovation going to be owned by the AI? Is it going to be owned by the creator of the AI? Or is it going to be owned by those who trained it? Or more pertinently, is it going to be owned by people who paid money to acquire this AI or use the results of this AI? Now, fortunately or unfortunately, in case of all progressions in humanity, in science, our law tends to play catch up. Copyright today is not really equipped to deal with these situations, and various jurisdictions around the world are still grappling with how best to regulate this, how best to find a most equitable solution. Many countries in the world today, including the US and India, offer protection under law for these creations only when the creators are human or where there is a significant human input. But what happens to these artworks when they have not been created by a human author and they still need to be commercially exploited, or authorship needs to be attributed to it? So keeping that in mind, I want to open this discussion now to our great panel, and I'd like to open it with James. James, as a creator and an artist, the field of what can be done, in how much time can it be done, what kind of creations can come out, is really set to change with how AI, once AI is introduced into this equation. What are some of your thoughts in terms of the challenges that AI creations pose to human creators, and what do you think the impact of this is going to be on the creative industries? As a creator, and of course, I would also love that if you speak with your hat as a lawyer, earlier in your career. James.
Okay, well, thank you very much. First, to begin with, I think the HAL 9000 computer from the film 2001, from 50 years ago, is alive and well today. Now, having said that, I can see reasons why we can argue about AI. People can argue about it. But the fact is that AI and HAL 9000 are here to stay. So what we have to have is a way of being covered legally as creators, as writers, as authors, script writers, book writers, things like that. The technology is still not there yet. Yes, AI can do paintings and things like those are much easier. But, for example, to write a novel or a screenplay, as writers, we may spend weeks and weeks working out the characters and their backstory, and very little of that may actually make it into the film or the book. But it's still there in terms of what the talent, the actors have to portray. A computer is, down the line will have to have these algorithms put in, and that's going to take time. And I think in one sense that gives us time to come to some kind of a legal conclusion with this. To look at it first from the practical standpoint, about a year ago, I was approached by someone to look at a business proposal from the USA about an AI program to write scripts based on input of genre, this and that. It's sort of like what the streamers are doing now. I think Netflix looks first at the algorithm, the model, and then they look at the story from there. Now, but that works if you're buying something that's already made. But it doesn't necessarily work if you're buying something that has to be created. So, because nobody knows how the audience is going to respond to the book or to the script. Now, anyway, when I looked at this, I found that at least that particular business proposal, it didn't stand for me, because it was too much R&D investment for the matter. That is really like trying to come up with the COVID vaccine. You know, it could be a black hole spending money. And some writing that I did see that it had done totally lacked emotion input. It was stereotyped characters saying things, and like in a practical way. In English, and I'm sure it's true for other languages too, but saying English, one can tell someone, I love you. But that's on the page. But what does it mean in practice? That's the whole story that's been built up. I love you could mean, yes, I love you and I want to be with you. I love you means that I really hate you. I love you means next time I see you, I'm going to kill you. So the question is, how will AI react to this? It's going to be solved one day down the line, but I don't think it's going to happen from day to day. Look at, for example, we translate something, we write something, and we go to Microsoft Word to translate something, or to do an editing for us, or Google Translate. And they just come up with literal translations, which are often not valid for what we want to do, whether we're writing as a lawyer or as a writer, as a novelist, whatever. So these are things that have to be confronted. And now, since we're going to be getting into what is the legal status of this, I think now is the time we can formulate conclusions. Publishers and creative people have to get together and come to arrangements and agreements on things while there's time. Because if we get behind the power curve, publishers and creators will not be running the show. The scientist will. The computer scientist will. And that, to me, leads, of course, into what will be the future of the writer. Now, I have something for that to add, but should I add it now or should I save it till later for after we've discussed some?
Sure, James. So we would love to go into it, but maybe, like you mentioned, if we don't find the solution today, we will probably have a situation where the computer scientists are running the show. And I think that's a great segue for me to, reflect this to Utpal next. Okay. As a computer scientist and a technologist, Utpal, what are your views in terms of the fact that why do people find it so hard to attribute ownership to AI? And as a technologist, do you think this is something which is feasible, or would you be happy to see a creation of yours or a creation of technology be an owner of AI? You think it is feasible, or would you side with the writers and the creatives in saying that whatever is created should always be owned by humans, and AI shouldn't be owning something like this?
Yeah, thank you, Rishabh. So am I audible?
Yes, Utpal, loud and clear.
So I'll go a little bit broader first, and then probably come back to this. And I think James has touched upon a couple of points here. So first of all, we should accept, and we should accept happily, in fact, that the technological, the innovation and the explosion that has happened in last 2 decades or so is so fast that unfortunately the regulators are far behind this technological explosion, right? So this is very unfortunate, but it is we'll have to accept that. And that is because there are no right forums available wherein this technology people and the regulators can sit together, sit across the table and discuss this. So I think these are very good forums, okay, wherein at least we can bring these topics out, okay, so that and leave with a thought to the audience, okay, so that they can start thinking that. So now coming to the question that you have raised is basically around the content, right? So who is the original creator of the content? Now, where the ownership of the content currently lies, how to transfer the ownership, what kind of a technology to be used, what kind of a contract, or nowadays it is called smart contract, to be assigned for this kind of transferring the ownership of a particular content from one person to another person. These are some questions has been discussed in the legal forums in all almost all the countries. Okay, and some of the countries they have taken some kind of a very straightforward decisions, like as you mentioned, like in US, UK, even in Nigeria, and some other countries. Like it will be human, right? So whatever these things are there, but as you also rightly mentioned, the process of building something using a AI algorithm is basically starts with the data. So AI cannot create anything of its own, okay, completely out of the box without some reference. So definitely it will have to take some kind of reference from the past creators. It could be one creator, it could be multiple creators. It could be a text, it could be a movie, it could be a music, whatever it is. But the intelligence should come from the human. So that is the first part. Okay, so I think the first question that we should raise is basically, is the ownership lies with those people who are the original creator of those things, which the AI algorithm has been trained. So that is number one. Number two, the developer, the data scientist who is building the AI algorithm, he plays him as a role, right? Because he trains the model, he actually tweaks the model, he fine-tunes the model, he does a lot of hyperparameter tuning, okay, to make the model perfect, okay, so that it can give a perfect creative output for any kind of content. Now the question is whether he should be rewarded with this thing. So the third thing is basically the actually implementer of that, or basically who owns that project owner, so whether he should be giving that. So I think, if you ask me personally, I think yes, AI algorithm cannot be an owner of something, okay? Because I think whatever intelligence it is getting, it is ultimately getting from the human only, right? So actually, we should assign it to some human, okay? But now there is also another concept which is going on, that is basically equitable human remuneration. Okay, how the remuneration can be divided into these different stakeholders who were involved into training the model, building the model, tweaking the model, and now the ownership of the model, AI algorithm, right? So that is also a big topic which is going on. So cannot be the only one owner. Probably it is multiple owners, or at least if it's one owner also, but the equity should go into different people. So that's what I think I would love to hear from Shruti and Shrey.
Thank you so much, Utpal. Some fascinating points you bring over there in terms of who should be owning it. Should it be the trainer? Should it be the creator? Should it be the owner of the AI? And as we develop some of these thoughts, I move to Suriti. Suriti, copyright law has existed to protect human authors, and much like Utpal mentioned, AI cannot be an owner. Should machines have a right in this scenario, or do you feel human authors should continue to do this? Are there any other frameworks that we can think of in terms of figuring out what ownership should be? And of course, we will get to equitable ownership later, but at a principal level, wasn't copyright law meant to only protect human authors?
So really interesting. Thanks to Utpal and James. I think they've laid out the industry stakeholder perspective really well. Before I think we go on to the question of what the law says, and you're right. Let's go to the question of what the law meant to do. The vision of the US copyright law came from the US Constitution. The US Constitution said that every single time there should be privileges granted to humans, there should be motivation that should be available to humans to create, because there needs to be progress of the science and of the arts. So from that US Constitution thread, the US copyright law comes out. And obviously under the copyright law, there have been various US Supreme Court judgments that have said the progress has to be of intellectual labor created by human authorship. And you are right. The theme seems to be that the reason copyright law existed was because we wanted to tell the artists and we wanted to tell the authors that if you create something, we're going to protect you. You're going to get revenues from it. This is what copyright is going to do for you. If someone tries to copy you, we're going to protect you. They're not going to be allowed to do so. Originality is going to be protected. In India as well, we have authorship protected, obviously under the copyright laws, but there's a beautiful difference between how the US and India is created. The difference is that under the US copyright law, as I told you, it says we are going to protect original authorship, and US Supreme Court interpreted as original authorship by humans. The Indian copyright law uses a very beautiful word. It says computer generated works are going to be works and are going to be owned by persons who cause the work to be created. So if we were to just draw a plain, simple interpretive clue from the Indian copyright law, we would say, oh, the person who caused the work to be created is going to be the user of the computer program, the one who's sitting in front of it. But the question is not that easy. The question is not that easy because copyright law is based on the idea of originality. So as Utpal put it beautifully, you have training data that is created by a person. That training data is then used to train the artificial intelligence. So is a work that comes out of the artificial intelligence really even original? If we are looking at artificial intelligence as just a pattern creation, it's basically an algorithm that creates patterns from learning data and then produces an output from those patterns. Is it really original? So as James put it, we haven't really gone to that level of artificial intelligence yet. We haven't had lots of creative output, say in terms of writing, but in terms of digital art, artificial intelligence has been doing beautifully. It seems to be that it is more a concept of I have taken motivation from Picasso or from Rembrandt, and this is what I'm going to produce. In terms of creativity, obviously the ambiguity of the word still remains a mystery for artificial intelligence, and we might solve it. So I think the current artificial intelligence technology is grappling between being a pattern creator versus developing actual intuitive output, which still seems to be something that is unique to human imagination. Intuitive creations at least still seem to be unique to humans. So from a legal perspective, I think there are multiple questions of one, is it original? If we do reach the question of it's original, then we go to the question of is it derivative? And I think we all know the complexities of derivative works under copyright. If I make something and there is a derivation out of it, then I own it. So if the training data is collected, as Utpal said, by a person, then anything created out of that data would be a derivative work, again, owned by the programmer. But the users in this case might see artificial intelligence as a tool. just like you would use Microsoft Word or Microsoft Excel, as we discussed, Rishabh, in our conversation yesterday. So I think the question still seems to be, are we seeing it as a tool? Are we seeing it as intuitive energy? Are we seeing it as a derivative work created out of training data? And I think that's the legal landscape that we're grappling with. The questions seem to be many and the answers do not seem to be binary. But as you said, we'll, I think, go I think at the later part, we can get to joint ownerships and different solutions of ownership. But I think laying out the base was essential. With that, over to Shrey, I guess.
Wonderful. Thank you so much, Suriti. I think that you leave us with an interesting segue. There are all these difficulties of imputing ownership of this creation. Should it, who should own it? Of course, a lot of this development in AI is happening because large corporations are putting so much investment into this, where they may not need to depend on humans to do something which a computer or a machine can do. So necessarily there needs to be some kind of balance that needs to be drawn. And that's where, Shrey, I come to you and I ask you this question: how do you see, what kind of a solution can we think of to balance the commercial needs of users of AI, who are the ones who put in the investment, versus the ethical needs of the law, of being fair and of being right, that if something has not been created by an individual, who should really own it? Should it be the corporation who bought it? What kind of solutions do you think today are the most equitable, and what do you see the path forward from here? Shrey, over to you.
Thanks, Rishabh. Before we discuss any kind of solutions, I think what is most important is to look at the objectives of why a certain act or a certain provision has been in place. Now, the whole objective of copyright laws has always been to protect originality, right? If I'm coming up with something original, if I'm creating it, it could be an art form, it could be music, it could be literary works. The whole objective was to tell these people, okay, there is law behind that, you will be protected, and nobody will be able to exploit your works without your consent, right? So the way AI has helped a lot of people is that a lot of people do think that works created by AI do not have that much originality backed by it, because AI essentially will always require human input. There will always be input, as Mr. Utpal clearly pointed out, that you have different data points that an AI collects, and only based on that is an output generated. So it can never be completely original. It can never be completely creative. So presently, I believe there are two questions that a lot of the states are grappling with. One, who would own the copyright in a work that is created by an AI? And second, who would be responsible for infringement by an AI? If an AI creates a work which infringes upon somebody else's work, then who would be responsible for that kind of an infringement? And problems, when you go into these problems, it just opens a Pandora's box, and you are faced with several other problems where you don't know how assignment or licenses of these copyright works will happen. Or let's say an AI is able to create a work which is obscene, then it's very tough to determine whether there is mens rea behind that creation or not. So who would be responsible for that kind of a creation, or what should be the term of that copyright protection? The way this has been able to be solved, a lot of states are taking steps to recognize AI. However, there are three major schools of thought that have come to light. The first, where states do not recognize AIs to be able to own or be the authors of any works created by them. So there's an outright denial of any sort of ownership or any sort of copyright protection to works created by AI, which would mean that ultimately works created by AIs are in public domain. So anything that is a product of an AI would be in public domain and would be able to use by all. Right. The second school of thought that is that a lot of states have also followed is that states attribute authorship of works created by AI to the AI itself. Now, again, if you delve into that, AI is not a natural person. All of the problems that we discussed before do apply to AI being granted authorship of its own work. So again, a lot of states are grappling with that issue. And the third school of thought, which I think is the most pragmatic of them all, I would say, is attributing authorship to works created by AI to the creators. Now over here, you have two different, two streams where this could go. It could go either to the creator of the AI itself, or to the user of that AI, to the creator who is using that AI to create a product. But whatever line you choose, this I personally believe very strongly that it cannot be equated, or it cannot be at par with someone who's not using AI to create a certain artistic work or a literary work or a musical work. For example, what was done in India some time back was authorship of the protection given to works created by photography was reduced. The number of years was lesser. It was because it cannot be equated, or it cannot be at par with someone who's actually painting, or who's actually creating that image using his own skill. So the question that remains is, if I'm a creator and I'm using my tools to create something, and there's a person who is relying completely on AI with minimal intellect input to create an output using that AI, should that be at par with someone who's not doing that? So these are the questions I feel that states are trying to answer right now. Equitable ownership and remuneration is obviously one great step forward, because that recognize all the players that have a role behind that creation, so they can be equally credited with that work. But yeah, that's what I think should be the way forward. Just vesting ownership of creative rights with the AI system is personally will open a Pandora's box with numerous complications.
Thanks for your thoughts, Shrey. You mentioned a lot of points, and I think there is a common theme which is emerging on the panel today, which is the question of, when training data has already been fed into an AI, what it produces, is it really an original piece of art, and whether for those reasons is it fair to attribute ownership according to the people who trained it. Shrey also mentioned about the fact that how there should be a distinction between somebody who creates a work of art on their own versus somebody who uses partially or fully an AI solution to create a work of art. I think this raises a couple of very interesting questions. I think the first, which James, I would like to come back to you for, is do you think it's fair to, so a lot of artists, whether human or whether an AI program, all of us depend on some kind of inspiration. We are a product of our experiences, as they say. And Rembrandt or Picasso or anyone who's making something, they build that on the basis of what they have learned, and then they add their own creativity to it. Do you think it's a little rich to say that if the same thing is being done by a computer program, which is trying to get to some kind of a creative work by using data or training materials from elsewhere, it shouldn't stand at the same pedestal? Of course, like Shrey mentioned, commercial rights to exploit it may be treated differently, but at least in terms of ownership, or in terms of giving credit to it, giving credit to a computer program for building it and saying that, this was built by a computer and not, the author is not going to be, a human. Why do you think that that is difficult? And, lastly, what you had left off in your first set of remarks, what do you think are some of the solutions to deal with the situation equitably, James?
Well, I guess I could take I don't want to say an extreme position, but a simple position, which is that, let's say an architect designs a house. At that point, it's a drawing. It belongs to the architect. It's a work of art. Okay. Now, when the house starts to get built, we bring in bricklayers, painters, everybody needed, electricians, and they certainly are not creative. And so by analogy then, if by analogy, we go to a computer programmer and say, I want to do a story with A, B, C, D in it. And then later G will do this and it will end this way. And I'm giving that input in. And now the computer programmer is, to me, like the type of example I'm giving is similar to the painters and the bricklayers and the people who is simply getting hired to execute an architectural plan called a story, novel, whatever. Now, how valid that is, I mean, how it will be accepted, that I don't know, okay? I'm not saying that, of course, the computer people are creating something when they create the program. But in a way that's solved, because the computer program is going to charge me money to give them my input to come back with another type of program that I want. My program is the finished story. So I think that's one way we could view it. Now, if that answers your question, I can go on to the second part.
Definitely.
Okay. Now, we've covered here through the other speakers that it's a matter of the attribution and how the monies will be split. There's a question of moral rights too, at least in Europe. And in other countries too. So how much is this derivative work an insult to my moral right if I'm the creator? Now, what is the ultimate solution, as I see? Because these questions are open answered and they're going to be hotly debated. I think that the solution, one solution could be that the major players get together and come the way, for example, publishers and say authors associations can get together, film financiers come together with the producers union, directors union, actors unions, and they negotiate type of agreements with clauses. I think this would enable things to happen faster. We could say that after 5 years or 10 years, this will be reviewed again by the players. And this will run faster than governments, because we all know that governments are incredibly slow in passing the legislation. And in Europe, we could be talking about this for 10 years. And in America, for a lot of other years. And unless we come up with it as the players, eventually the major players will take over and dictate what they want. So the end solution I see is if the parties get together, we can come up with an idea as is similar, say, in the music field. The royalties, there's fees paid up front, yes, to everyone. Composers get fees, the musicians get fees and things, but then there are royalties that are shared between the performer, the musicians, the composer, the lyricist. And that's something that I think would be a good solution and avoid a lot of litigation.
Thank you, James. So 2 interesting points from James, and I'd like to open this to the panel. Utpal first. So on the first part of the question, Utpal, James mentioned that a machine always does the bidding of a human. So the human is going to give the vision, and the machine is going to produce accordingly, whether it is an artificially intelligent one or otherwise. What are your thoughts on that? And the second part that James mentioned was hinting to something you had also hinted on in your first set of remarks, where you mentioned that there could be an equitable distribution of royalties and the spoils of exploitation of that creative work. So quickly, if you could run us through some of your thoughts in the next 1.5 minutes. Thank you.
Yeah, I think pretty much everybody has covered that thing, so I don't want to repeat that. But now it is, so we are talking right now only on the copyright part of it. So the same concept has already come into what we call as NFT, okay, non-fungible token, okay, so which is in the metaverse world. Okay, wherein we actually, so now all contents are almost the digital contents, or if it is a physical content also, you can convert it into digital content, and you can take the ownership, you can define the ownership of that content. So now, like if you think of a decentralized kind of environment, like in the metaverse, or in the world of crypto, in the world of these things, this has already been happening in that way, because anybody can create something, okay, and he can claim that this is my original this thing. But there is a procedure there, okay, wherein we can define that whatever you have created, okay, it is once assigned to you, and a smart contract is assigned to that. Now you are the original owner and creator of this content, and nobody in this world will be able to, because this is running on the blockchain. Okay, so nobody in this world will be able to tamper with that. So that is a good thing which is coming up. Okay, so that's how the NFTs are coming. So I'm pretty sure, like tomorrow, any music you create a jingle or any kind of text, okay, it could be an article or could be book or something like that. Everything is going to be an NFT, non-fungible token, and the ownership will be assigned to a person. Now what he can do is he can sell it, he can auction it, whatever he wants, he can do it. But while doing that, there will be a ownership transfer, and that will also be transparent across the world, and nobody in this world will be able to tamper with that also. So that is going to come, and I'm hopeful that in the coming few years, these things will come, and all those ambiguities which are going on, now it will go. So now you made it very, very clear, and many of the governments has made it very, very clear that it should be human. The only thing left is the equity part of it. Okay, and second thing, once it is in the blockchain kind of a thing, then there should not be any kind of ambiguity. I mean, it will be very, very transparent.
Very interesting thoughts there from Utpal. Suruthi, I come to you next. So Utpal mentioned that one of the ways to solve for this is to look for inspiration from already existing models in the Web 3.0 ecosystem, where we look at how owners of NFTs have smart contracts that help distribute equitably, and whatever is commercially agreed between them, the whatever commercial spoils are made from the exploitation of that NFT. Do you think a similar kind of a model can work for products of AI as well? Maybe as Utpal mentioned, using blockchain to ensure validate ownership of this and have the entire value chain of the people who benefit from a particular piece of artwork mentioned over there? Or is it more likely that we are going to see a new form of copyright societies which earlier existed for exploitation of works of art from authors? So what are some of your thoughts, and do you think there are any other frameworks also out there which we could use to come to find a way to exploit creative work produced by AI?
Yeah, so this is a very interesting question, but I think if we take the base value of what we're discussing, it is, yes, while the blockchain might be capable of validating authorship, the idea and the question of who still remains the owner is open, because I can put on the blockchain that I am the programmer of the AI. I could also be the first user of that AI. And I might have produced something as a programmer and the user, and then it is absolutely clear, yes, I own it. And this is, we're assuming that we're not giving AI authorship. But the second question is, I built the program and I've given it to someone else to use. And as James mentioned, I have paid a subscription fee to the producer of the AI. And now, even if you put it on the blockchain, who decides the question of whether the programmer is stated as the owner, or whether the user of the program is stated as the owner? I think that still remains open. So I agree with Utpal that yes, artificial intelligence is capable of validating ownership, but the question of who should be the owner, I think, still remains open. I think we go back to what Shrey said. It's a very interesting question of liability also, right? Does the programmer really want to take ownership of what the users do with the AI program? Is that something that I really want to do? And if I take the time and effort to train an algorithm with, say, 100,000 paintings that were produced between the years of 1800 and 1900, there might be obscene art that is produced from those paintings. Do I want to be held liable for that? Maybe not. And as the user, do I also want it to be public? Now, Shrey had mentioned some other thing that, AI could produce something and it would generally go in the public domain. That's a solution. But users could also want it just for personal consumption. Everything that the AI produces does not necessarily need to be public. So I think all of these thoughts come down to a few, I think, distilled questions. First, motivation. Going back to the thematic idea of, does copyright want to protect human intelligence or labor? Or are we now saying that people who produce algorithms also need this motivation? Because as everyone has come to the conclusion, there are people behind the creation of the algorithm as well. Do they need copyright motivation? That's one. Second, the question of human spirit. Do we think that if content is created by artificial intelligence, that the human spirit is going to take a hit? Are humans going to now feel that their creativity is not up to the mark? Is that a threat? And in case that is, what happens to the argument to that human spirit, which is that there is always space for more content and more creativity, right? So that there's a debate there. And I think in terms of solutions, I think what the industry has done over here, considering that the US Copyright Office has said that artificial intelligence cannot be the author of a copyrightable work, the US industry has mostly gone on something called joint creative agreements. I am the programmer, you are the user. We're going to get into an agreement and we're going to decide who makes what part of the money that we earn from the work that the AI produces. But there is also that interesting question of, should we all just let it go to public domain? Because, and I agree with the open source environment in this, the data that is being used to train artificial intelligence is data that is in most situations publicly available to those people. So if today they are using digital copies of paintings that were created between 1800 and 1900, the artificial intelligence company is not paying those painters. That training data that is being used for free. So there is a question of, then whatever artificial intelligence produces after taking up free training data should be free for public consumption. But then there is also a question of what happens to proprietary data. I could be using artificial intelligence for complex financial problems, and the financial data that I input into the artificial intelligence might be something I might have paid a lot of money for. So I think, as Utpal mentioned, yes, equitable remuneration of where the data comes from, who is going to be ownership, who's going to own the work of artificial intelligence. I think equitable remuneration is going to be a very important question. I think lack of regulation is a problem over here. we cannot just let industry decide, because whenever the industry gets to do whatever it wants, there is a question of exploitation. And I think we need to prevent that. I think regulators need to step in. I believe Canada already has. Europe might be coming out with some regulations soon. I think the US Copyright Office is very clear that they're not going to want artificial intelligence to own anything. Are they going to put out any regulations regarding remuneration? I doubt it. We haven't seen any inclination to do so currently.
I'll
But
need you to wrap up. I'm sorry.
yeah. So I was just
out of
going to
time.
conclude that. I was just going to conclude that I think equitable remuneration would be a question open, and I think regulators do need to step in as far as questions of ownership are concerned.
All right. Thank you so much. I think those are pretty much, we can say concluding remarks. But before we conclude, we have about 2 or 3 minutes odd left. I think we've received some questions from the audience. And the first question that we've received, it says, should text and other data sets used for training an AI to be allowed to be freely used by the AI developers, or should a license fee be payable to the owners of copyright and such works? How should the licensing regime work? So this question, maybe, I'd like to put to Shrey. Shrey, what are your thoughts on this?
I think Surati very comprehensively, pointed out the entire system that is in existence today, where almost 90% of the data being used is already in public domain. So licensing fees or attribution of their authorship and ownership does not really come into play, because it's already in public domain. It is available and freely accessible to all. And that's the data that is being used by these AI systems to create outputs. In other cases where inputs are being used, they are mostly personal in nature. For example, if I'm a huge corporation, I'm using my own data. I'm using my own instances. For example, Google will rely on data collected by its users, which they own, to develop an AI system which will be able to create an output. So in that case too, it's me using my own data. Of course, if you're using data that does not belong to you, if you're using texts or images or even sound recordings that do not belong to you, then a licensing structure does need to take place. And we've discussed blockchain and how NFTs have been working and how they have made it very convenient to attribute ownership and to make sure that there's a structure, that there's a secure structure that cannot be compromised or altered. That is one way of making sure that these licensing or smart contracts can be entered into with people that own this this data that is being used for inputs. But as far as data in the public domain, or as far as my own personal data being used to create these outputs is concerned, there's no need for licensing fees. Of course.
Noted. Thank you, Shrey. Team Pragati, are there any other questions from the audience that you have received?
So we do have a lot of questions from our audience, which we'll be mailing each one of you so that our audience can get answers out of it. We were so intrigued by all the opinions that you all shared. It was such an insightful session, and I would really thank each one of you for joining us today. Just like our audience today, I was so engrossed in the entire session. It was wonderful. We are really delighted to have you all, each one of you. Thank you so much and have a great day.
Thank you.
Thank you
everyone.
Thanks.
Thanks, everyone.
Thank you.